We'll get started here in just a minute.
Hi, Jen.
Hi, good to see you all.
Hi, Jen.
Is that Beth? It sounds like Beth. Yes,
Yep,
it's Beth. Hi, Beth.
it is. Nice to see you.
I remember your voice from the office next door.
That's pretty good. All my blabbing on the phone.
I remember your Spanish specifically.
Ah, probably not very good.
I thought it was, from someone who doesn't speak it, it's always impressive.
Well, that's good. It's okay. Did you know
Okay.
I started there as a staff attorney now? I can't remember if that was the
Yes, I
like
was thrilled because that's been in the works for what, like 8 years?
7 years, right? Oh,
Yeah,
7 years, yes.
I was thrilled. I think it was Sarah that told me.
Yeah, I'm excited. I'm enjoying it.
Good. Okay, we'll go ahead and get
Hi,
started.
Jen.
Hi, is that George?
Yes.
Hi, George. Welcome.
Thank you very much. I appreciate it. And how is
Yeah,
the baby doing?
she's great. She's downstairs with my mom, actually. She's hopefully you can't hear her. She's happy and wild and hopefully contained.
That's good.
So we'll go ahead and get started. Thank you
Okay.
all for coming out. It's good to see you all. Uh,
I'm gonna mute myself just because of my kids. If
Sure.
that's fine.
Go
Okay.
ahead.
Thank you. Yeah.
I can do it for you, actually. Okay, there we go. So hi, everyone. I'm Jen White. I'm the founder and executive director of Arise Immigration Services. So if you're not familiar with us, we have a dual mission. We provide free legal services to immigrants here in Pittsburgh, Pennsylvania. And kind of related to that, and secondarily, we provide training and mentoring to advocates around the country as they work on our real cases together with us, with someone who's experienced. So we're kind of like a law school clinic, except we're not connected to a higher ed institution. So this training series, it's a 3-part training series, came out of some of the questions and issues we've confronted in our casework through Arise. So I say that because if you have ideas about future trainings, please let me know. So this is a time to take a step back and just dive deeper into some of these topics that come up that we can't always address in full because we're always dealing with deadlines and, the pressures of casework. So tonight is part 1. We'll be talking about ethics. All of these are at 7 p.m. Eastern. On March 7th, we'll be talking about trauma-informed interviewing. And then on March 11th, we'll be talking about working with translators. So if you need a certificate of attendance for any of these sessions, just email me. I'll put my email in the chat. Like, for example, if you're applying for DOJ accreditation, you probably want to keep track of your trainings and get that documentation. So just let me know and I'll send you one directly. Okay, so let me introduce you to our speaker, Danny White. So, well, first of all, Danny and I are married. He's downstairs in our family room, and I'm upstairs in our attic office. He looks comfier than I am. So it's nice to have this conversation with more people because we tend to talk about this stuff all the time, at the dinner table or wherever. So Danny works at the Office of Disciplinary Counsel here in Pennsylvania, and he prosecutes lawyers for ethical misconduct. And he's worked on a lot of immigration cases. So he's gonna talk kind of broadly about like general themes that he sees in terms of the misconduct he prosecutes. But for those of you in other states, or for those of you who aren't interested in becoming a lawyer, maybe you want to practice immigration law by becoming a DOJ rep, or you just want to do something that isn't even practicing law, you just want to be involved to some capacity. What he's going to talk about is still very relevant to you because these are trends that we see all across the United States. And oftentimes they're really concerning trends. So he will cover what he does in his prosecution cases. And then I'm just going to mute. There we go. And then I will cover the federal regulations at the end that relate directly to Department of Justice accredited representatives, because they are a bit different than what most attorneys deal with at the state level. So anyway, I'll get there toward the end. But just bear in mind that what Danny's going to talk about, these are pervasive problems across the U.S., even though his practice is limited specifically to Pennsylvania. So hi, Danny. Welcome.
Hi, thanks for having me.
Yeah. So let's dive right in. Can you start with the two primary ethical issues you see and you prosecute?
Sure. So when I started this work, the misconduct I thought I would see in immigration is not really what manifested. People say immigration law rivals the tax code in its complexity. So I thought we would see a lot of well-meaning immigration practitioners making honest mistakes. The other thing I thought I would see a lot of was conflicts of interest because there's a lot of dual representation in immigration practice. You represent husband and wife simultaneously, or employer and employee simultaneously. But instead, what we saw were like two buckets. One is out of a BIA decision from the 80s called Matter of Lozada, basically alleging ineffective assistance of counsel in removal proceedings. And if you go back and read that decision from the BIA, they actually say one of the requirements if you're seeking to reopen your removal proceedings based on ineffective assistance of counsel is they don't actually say you have to have filed a disciplinary complaint, but they kind of say if you didn't file one, you have to tell us why not. So basically the requirement is to file a disciplinary complaint. So we see a lot of those complaints where a foreign national is trying to reopen a removal proceeding where they got a removal order. And generally those complaints don't really go anywhere. I'm not saying that they aren't meritorious. I haven't seen one yet. The other bucket of misconduct we see is more nefarious exploitation. People who are being opportunists. They see a vulnerable population and they want to take advantage. So the scheme that I've prosecuted a couple times is this asylum cancellation thing, where an undocumented immigrant walks into a lawyer's office and the lawyer finds out they've been here for 10 years, but they're not in removal proceedings. So he says, I can get you a green card. And what they end up doing is they file a frivolous asylum application because they know that CIS won't deny it. They'll refer it to removal proceedings. And once it's in removal proceedings, then they can pursue cancellation of removal. So if you know anything about cancellation of removal for non-permanent residents, it's a very, very difficult benefit to obtain. We prosecuted a couple guys. One was publicly reprimanded. The other was suspended for engaging in this scheme. And really the problem is that theoretically asylum and cancellation of removal are mutually exclusive benefits. There's a 1-year bar for asylum. You're supposed to apply within 1 year of entering, and you need 10 years of continuous physical presence for cancellation of removal. So not to say that there aren't clients out there who could be able to make a successful claim for an exception of the 1-year bar at the same time that they satisfy the continuous physical presence requirement and cancellation, but that would be unusual.
I have a follow-up question about that. So this idea of applying for asylum for purposes of getting into removal proceedings for ultimately applying for cancellation, that's a complex analysis, right? To see like if they could be eligible for both, because in rare instances, people could be. So Danny, do you have advice for folks who are newer, right? Maybe they're in a law practice or like at a nonprofit and they start to suspect, like, is this the situation that you're talking about? What kind of red flags would come up to indicate that this is a problem and it's unethical?
Sure. So what I would be looking for is this strategy. It's very risky. You're taking someone who's not on the government's radar and then putting them on the government's radar for the purpose of seeking a benefit that's really not granted that often. So what I'd be looking for is, first of all, that they're advising their clients of the risk they're taking, because that's a substantial risk. You could take somebody who could be better off doing nothing, applying for nothing at all, and just hoping the government doesn't find them, and essentially getting a removal order for them with no avenue of relief. So first of all, advising the client of the risks. Second, before they file the 589, before they put the wheels in motion here that they can't stop, I would be looking for them to, obtain evidence to support both the asylum claim and ideally a claim for an exception to the 1-year bar and the cancellation claim. If you're hanging your hat on cancellation, then you better have evidence to establish their physical presence for the relevant 10 years. Or if they left, that the dates, you can prove the dates, you have the travel details, and it doesn't meet the bars. I think it's 90 days or a total of 90 days. I forget, whatever it is. And the exceptional hardship. That's usually where the cancellation claims fail. Those opinions on cancellation claims are heartbreaking. That this is hardship, but it's not exceptional hardship. But you really need to have your ducks in a row for both claims before you file this 589 application and set things in motion that you have no way of stopping.
Yeah, so just kind of a practical tip there to protect yourself as an advocate. There are times where you could file a weak application for someone, like a weak asylum case that could ultimately get them into removal proceedings. I think it's really a smart move to put that into the retainer agreement that you sign and the client signs, to put it in writing that they've been advised of the risks, and to be explicit that there are risks. That's one of the ways that I protect myself. I know, Danny, you can't give legal advice outside of, the work that you do, but do you have any comment to that practice?
Yeah, sure. I mean, obviously when I get involved, I'm looking for documentation.
Yeah.
If a lawyer tells me that they warn the client of the risks, I interpret that a lot differently than here's a piece of paper where I told them the risk and they signed it and they dated it. Those are two very different things when I'm looking at something in retrospect. The other thing I wanted to mention too, there's the AILA, the American Immigration Lawyers Association, put out a practice advisory. This is probably 10, 15 years ago. I think they just recently sent out a new one, essentially talking about this particular mechanism to try and get someone relief. And the one from 10, 15 years ago has a checklist at the end saying these are the things you should make sure of before you embark on this. Do they have a cognizable asylum claim? Do they have a claim for an exception to the 1-year bar? Do they have proof of physical presence? Do they have a strong claim for exceptional hardship? So I would stop short of saying my office would endorse that advisory, but I've reviewed it and I personally agree with the things they say they're in and the checklist at the end.
Yeah, and if anyone wants the revised copy, the recently released one, I have it through AILA, so I can give it to you because I know a lot of you aren't AILA members, but it's really good, very helpful. Okay, so let's move on to, I don't want to mention the case name. I don't know if you want to mention case names, but the case involving like the dishonesty with the attorney.
Sure. I can mention that name. That's a public case. There's an attorney in the eastern part of the state named David Piver. So essentially, this is a case that doesn't fall in one of those two buckets I was talking about. It was a unusual circumstance. So he ended up getting suspended by the Board of Immigration Appeals following a criminal conviction. And then my office imposed what's called reciprocal discipline, where we basically said, the BIA suspended him, we should suspend him as well here in Pennsylvania concurrently. So the facts of the case, he filed a 485, an application to adjust status. And it was at the height of the Trump administration, they had just changed the 485 to include a question asking if the applicant had ever falsely claimed U.S. citizenship. That's one of the questions on the 485 where you can't answer yes. If you answer yes, the application is denied, full stop. So Mr. Piver filed the application. The answer to that question was no. They go to the interview, and during the interview, the applicant reveals to the interviewer that he had, in connection with previous employment, he had submitted an I-9 and thought he claimed therein that he was a U.S. citizen when he wasn't. So Mr. Piper stops the interview, takes his client to what he thought was a private room. And that's another cautionary tale of this case is when you're on U.S. government property, don't assume there aren't people listening. So anyway, they end up pausing the interview and withdrawing that 485 application. And then they refile another 485 application. And this is really where the problem comes in. He answers that same question the same way. He says no. So that's what led to his criminal conviction. I believe he pled to misuse of visas or something like that. And then the criminal conviction triggers professional discipline. That's where my office gets involved in EOIR disciplinary counsel. So the lesson from this case is not that he should have answered the question yes, because he would have told you, if you're going to answer yes, you might as well not file the application. But if you're going to check no, you at least need to explain. His position was that there were some statutory defenses he intended to raise that he would be precluded from raising if he had answered yes. So don't just check no. If you check no, put a little asterisk, put an explanation in. That would have made things a lot different on my end in terms of professional discipline. If it's not just a no and you hope they don't catch it, if you actually explain the circumstances, it's a lot harder to prove dishonesty then.
Yeah, so I think this story is really helpful for a lot of reasons because it's one of the few ones that I think is a little bit sympathetic in terms of like the advocate's position. Like obviously we shouldn't lie. I think we all know that. But there are situations where I've actually worked on that particular issue before where a client voted before he became a citizen. He didn't know he wasn't supposed to. So the answer to that question was yes, right? And we were actually able to get around it through very thorough explanation and removing him from like the voter rolls and all of that stuff, documenting all that stuff. But the point is, you really have to go to great lengths to explain when you have a bad answer like that, but still, of course, put the correct answer, the honest answer. And one of the difficult things about being an advocate in this space, I think, is that a lot of times as the advocate, you're asked what the answer should be to a difficult question or a question like that the client might be waffling with, or the client might not understand. So I've been in that position quite a few times where a judge has asked me to explain why my client isn't making sense, or an immigration officer is asking me the same thing. And I always decline to answer. I cannot testify. So I always defer back to my client and say, could you rephrase the question, ask the client again? Because these kind of situations come up where I'm sure this individual didn't understand the significance of the paperwork, right? That's usually what happens in my experience. And so that's why it's sympathetic, right? You can understand why the lawyer would kind of want to cover for the client, even though that's not honest. So the point is protect yourself, even when it's uncomfortable and even when your client has really gotten themselves into a pickle, because it can result in a criminal conviction and losing a license. So actually what Danny said is exactly what I do with the asterisk and then using, a thorough explanation to explain why, the client did something that made them inadmissible or whatever the case may be.
Right. In that particular case, I think it would have been incorrect for him to answer no as he did the second time. But, if he had provided an explanation, that would have been more defensible. He probably wouldn't have been criminally convicted, probably wouldn't have been suspended.
Right. So check yes and provide a lot of documentation and explanation and make sure the client is advised of the risk. Put it in the retainer. But it was a shady way to do it, to resubmit the application after this was already on record. So.
Right. Yeah. And that's another cautionary tale. The government keeps track of things like that. They know what happened in the prior interview. They know what the prior 485 said. And that follows you throughout all of the offices, all the interrelated alphabet soup agencies and immigration. They all know what happened before other agencies.
Yeah, and it's surprising to me to see other advocates do that same thing where they submit a duplicate application or, something similar to that, maybe a subsequent affidavit that contradicts something that is in the file already. This happens a lot, and it's really problematic because dishonesty is so difficult for your client to overcome if the government thinks they're being dishonest. So yeah, that's why, even though this might seem obvious to you not to do this stuff, it happens. It's pervasive. Okay, so switching gears again. Conflicts of interest, super common in immigration practice. Can you explain big picture what that means, what a conflict is?
Sure. So generally, when a lawyer represents somebody, they have an obligation, a duty of loyalty to zealously represent their client, to use any information they learn to the benefit of their client, and to the extent they're permitted ethically to withhold information that would be detrimental to their client. So where conflicts of interest usually manifest are when there's multiple representation, when you're representing multiple people in the same matter. And that happens all the time in immigration. I mentioned earlier, you represent husband and wife, mom and daughter, employer, employee. And usually that's okay. That's what we call a waivable conflict of interest, because everyone's interests are aligned. And by representing one, it doesn't detract from your representation of the other. But where the problem comes in is when the circumstances change. And perhaps an example would be the best way to explain this. So let's say you're representing a married couple. Wife is trying to obtain status through her U.S. citizen husband. And then for whatever reason, you learn that the husband is abusive. So now wife can pursue a VAWA claim, and that might be a better option for her than the 485, particularly if husband is using the immigration process as a control mechanism over her. Problem is, you already represent husband. So in order to pursue the VAWA claim on wife's behalf, you have to accuse husband of abusing his wife. And you can't do that if you represent husband. So when a situation like that manifests, the way you cure that conflict of interest is by withdrawing from both representations, telling them to get other lawyers. And that's similar circumstances can manifest in the employment context. If employer calls you up and says, "Hey, remember we did that H-1B visa for so and so? We're going to fire him. Can you help us fire him?" The answer is no. You can't help them fire him because you represent him too. So that's generally the way conflicts of interest work in the immigration context.
And they're really easy to miss. A lot of immigration lawyers struggle to identify conflicts and then, take the necessary action. Any thoughts on why that is, Danny? Why they're so difficult for legal advocates to identify?
So they are very fact intensive. I mean, you really need, in order for me on my end to prove a conflict of interest, I need to explain how your representation of one of the clients was limited, or there's a risk that it would be limited, and that's a pretty complicated analysis sometimes. Usually, the way to get out in front of it is to explain things to the clients from the jump, and the big thing is confidentiality of information. So if you're representing multiple people in the same matter, there's no confidentiality among them. So if husband and wife, if you represent them both, and wife comes to you and says, "I'm going to divorce my husband," that's not something you can withhold from husband. So usually the way to avoid problems is from the jump to explain what a conflict of interest is, how circumstances could change and manifest it, and what that would mean in terms of your representation of them individually.
Okay, we have a good question here from Mary Kay, and I think I'll take this because I know, Danny, you can't give legal advice, but jump in if you feel comfortable. So
Okay.
What do you say to the couple why you are no longer able to work with them? Great question. So generally the way I do it is I give very, very little information, because at this point, the couple, each party has different interests, right? And I'm still bound to confidentiality. So I tell them, "I'm so sorry, I can no longer represent either of you. I have to terminate my representation. Here's a referral list for other legal advocates in the area." I highly recommend you contact them as soon as possible. So that's the way I handle it. Anything to add, Danny?
No, I think that's correct.
Yeah, I think you have to be really careful about not like favoring one over the other and not engaging further at that point, just again to protect yourself. And if they ask you why, you can say, I'm sorry, I'm bound by confidentiality. I can't give you any more information. I wish I could, however you feel comfortable explaining it. And then making sure that you stop it at that. I suspect that one of the reasons why immigration advocates are so bad at acknowledging conflicts of interest is because they tend to have big, soft hearts and they want to help the vulnerable party, right? I've seen that a lot, where they want to keep the person that's been through the abuse and still represent them. But we need to be mindful of the ethical limitations there.
Yeah, you can't do that. You can't pick a side. Once you've represented them both, you have to represent them both zealously.
Yeah. Okay, so I guess this is a good time to transition to Q&A because I think I see another one in the chat. So please feel free to either unmute yourself or put any questions for Danny in the chat. Okay. Can you tell the clients individually to get their own representative in a VAWA case? Okay, so I would say no, I would not give legal advice at this point because again, like that's adverse to the abuser, right? So it's a hard situation because you want to help, right? But I would say no. What I would do though, is I'd give them a list of referrals for nonprofits, or lawyers or law firms and encourage them to do a consult. I would do this to both people. So I think that I can do this with a clear conscience ethically so that I'm basically prompting them to say like, okay, go see someone else to see what you're eligible for. So in some ways that's almost like code. And I hope that they'll be diligent and they'll do it. But I'm not at the same time pitting one person against the other or like jeopardizing one person's interests in any way.
Yeah, I think
Can I?
I'm sorry, go ahead.
Hello. I just wanted to real quick on what Jen had said. This is Lauren and Jen, and I'm driving, so I'm so sorry. But Jen, would you at the very least say that the reason I can no longer represent you is because of one of those conflicts of interest that I was taking care to remind you could happen at the beginning when we were signing the retainer?
I wouldn't get into anything personally.
No, not even to say the reason, because then you appear to be like I mean, I would be afraid that I would appear to be just a flaky person who jumped ship. Or
Yeah,
like
definitely. I think people have definitely mistaken me for that. But
okay.
I don't really see how that helps. And it
I
just kind
guess
of
that would be the
opens the
same type
door.
of clue that you were saying before, that, and a cover for yourself to say that um, I don't know. I just didn't
What I
realize that
have
that would be
said
a,
before is I can't, for ethical reasons, proceed.
okay.
It's just
Okay.
kind of
Okay.
vague, like more vague than a conflict, but
Okay.
I think a
Okay.
helpful way to think about it is to put yourself in the shoes of both of the clients and consider how you would feel if your attorney had did that. So in the VAWA example, if you're the abuser, the client who's perpetrating abuse, and your attorney told the victim of your abuse to go find a lawyer who will accuse you of abuse, you'd be pretty ticked. So that's probably the way to think about it, and why you have to be vague when you're getting out of those situations.
okay. So I'm just going to go through the questions here, and then Hillary, I see your hand up. I'll come back to you. Okay, so from Robin, I assume you have jurisdiction over accredited reps too? No, so Danny only prosecutes Pennsylvania lawyers, or misconduct in Pennsylvania. Is that a fair summary?
Yeah, so our jurisdiction is limited to attorneys. So Pennsylvania attorneys committing misconduct anywhere, or attorneys who are not admitted in Pennsylvania who are either committing misconduct in Pennsylvania or misconduct that affects Pennsylvania people. We have no jurisdiction over accredited reps. There's actually a different disciplinary counsel I think it's through the Executive Office for Immigration Review, and they have jurisdiction over accredited reps.
Yes. And so if you want more information about that, let me know. Like I can forward you to the website that explains that office that investigates and prosecutes. But at the end, when Danny's done, after we're done with Q&A, I'll go over the federal regulations that apply to DOJ reps. I'm just going to go over the high points. And these federal regulations also apply to immigration lawyers, but it's the body of rules that DOJ reps would be most that apply to DOJ reps to keep them ethical in their practice. So it's different than what rules Danny enforces. Just let me know if that doesn't answer your question, Robin. Would you then follow up with a letter for the file and for both of the people documenting your conversation that you are withdrawing? So yes, good question from Christina. So I would put in writing that I was terminating representation, and I would put a little memo in the file documenting my explanation to them and any questions or follow-up that happened, so that it's in writing again, mostly to protect myself.
Yeah, and I mentioned that the conflicts of interest are very fact intensive. That's why people struggle with them. Dates are incredibly important with conflicts of interest. When you learned the information that made clear to you there's a conflict, when you terminated the representation, what happened in the interim, that's all incredibly important, the dates.
So question from Mary Alice, can the advocate share information with the new advocate someone chooses? Yes, absolutely. So we deal with this all the time. So the process that happens is, say it's your VAWA client who's now eligible for VAWA because of the abuse. They find a new advocate. That advocate should request the record from the prior advocate in writing, and then that prior advocate would hand over the file to the new advocate. Some of it might be like the memo that was written. I'm not sure if they are if they are obligated to share that. But all of the stuff related to the case, particularly anything that was filed with the government, that would have to be turned over to the new advocate.
Right, the case file belongs to the client. So if the client asks you for the case file, their successful counsel asks for the case file, that's technically their property, they're entitled to it.
If everyone could mute, please. There's some background. Aren't there exceptions to what the client is entitled to, though, like in terms of the lawyer's work product?
So the work product they're entitled to. The exception that comes up a lot is what's called an attorney's lien. If a client hasn't paid their bills, if they owe the attorney money, and the attorney can withhold the file without causing prejudice to the client, then an attorney is allowed to withhold the file until they get paid. So that comes up occasionally.
Okay. Question from Cindy. If they go to another accredited rep or lawyer, won't they be told the same thing in a VAWA situation? So I think if I understand your question correctly, the difference in them going to a new lawyer, like the VAWA applicant, is that new lawyer or legal advocate doesn't also represent the abuser. So they are then free to zealously represent the victim of abuse with a VAWA case, without having to worry about this conflict of interest, also having previously represented abusive husband. So that's why they would go to a new advocate. Just let me know if I misunderstood that. Okay. So separate files for each client, even when you represent both. So generally, what I've seen both in private practice and in nonprofit practice is that for one case, there's usually one file, but it just kind of depends. Like, it's possible to theoretically have two for two different clients. But you would only be turning over, like in the VAWA example, the client file for like the victim of abuse, the wife, not necessarily the husband's file, because it's basically his property. Is that a fair explanation, Danny?
Yeah. So the office management stuff's a lot outside my purview, but yeah, that I think that would get complicated if you had a combined file for them, because then abusive husband would be, again, be pretty ticked if you're providing the abuse victim's new counsel with information that should be protected by confidentiality.
Yeah. If it was filed with the government, though, already, like wife was beneficiary and husband was petitioner, then she would be entitled to that, what was filed.
Correct. Yeah, it'd be part of her file, correct.
Okay, so Hillary, coming back to you, I saw your hand. Go ahead.
Yeah, hi. Thanks so much, guys. Super interesting. I'm having I'm a visa graduate and a college professor at Arcadia University. And I'm having flashbacks, happy flashbacks to when we covered conflicts of interest in our visa training. I forget which module that is. But Richard Green, who I'm sorry, I don't know. Hello, Richard, had a question in the chat that I wanted to bring forward and sort of add to. So he had asked in the chat, in domestic violence cases, would you be bound to notify police? And this is we had so another person that I was in visa with that many of you know, Cindy Levy, is a retired therapist, and we both had a similar question in the sense that, so as an educator, I'm bound under Title IX. I'm a mandatory reporter. So if I hear about, you know, domestic violence, sexual harassment, I'm bound by law to report that to the appropriate mechanism within my institution, which is, we have a Title IX office, right? And Cindy, as a retired, you know, therapist, social worker, had, you know, it's a different set of regulations and a different institutional structure, but similar process. We're mandatory reporters. And so we had brought that forward to Michelle, and that was an unfamiliar concept to her. And I don't remember if we ever like figured it out. So here's our moment to figure it out if you guys know. Yeah.
Yeah.
So like, are you obligated? Are you ever obligated to inform? And if so, what are the conditions under which you are?
Do you want to take that or you want me to, Danny? Go ahead.
Sure. So my understanding is lawyers, legal counsel are not mandated reporters. So I don't know how it would shake out if a lawyer was also a university professor or a social worker who would be mandated to report stuff under in that capacity. I don't know how that would work out. If, you know, your obligations under one profession require you to violate your obligations under the other. I don't know how that would shake out. That sounds like a terrible situation. But the way the confidentiality rule for lawyers works is the default is you can't reveal information like that. There are exceptions. One of the exceptions being to prevent reasonably certain harm to another person. So it will depend on the circumstances. If the client comes to you and says, my husband beat me once a year or two ago, then I don't think you can disclose that to the police. If they say, my husband beats me like clockwork every Tuesday at 7:00, then you can, because this coming Tuesday, he's going to beat her again. So that's, I'm simplifying it a little bit, but that's generally the way the confidentiality rule works. It's Rule Professional Conduct 1.6 for lawyers.
Yeah, another kind of complicating practical point here is that many immigrants are really fearful of reporting to the government for obvious reasons, right? Particularly if they don't have status. So there have been times where I've been working cases and the abuse was unreported or the trafficking was unreported, and I've asked the client if they would like me to report for their protection first and foremost, but also sometimes they have to report to get documentation for certain case types, like a U visa, for example. So there are times where you kind of have to be careful with that, because obviously we're not witnesses, right? We don't have personal knowledge, but I have offered to be there with the client and to help them draft something that's in their words, that kind of thing, to get the ball rolling and to reassure them that these are what the risks are, but these are what the potential benefits to you could be, especially in terms of protection.
Thanks.
Okay. Did I miss any other questions in the chat? Please speak up if I did. Or feel free to just unmute yourself or put any other questions for Danny in the chat. Okay, great. Well, thanks, Danny. That was helpful.
Yeah, of course. Thanks for having me.
Yeah. It was a nice chat. These are the kind of dinner time chats we have all the time. So, oh, go ahead. I see Mary Kay. Go ahead.
Mary Alice?
Real quick one. So a lot of times we deal with people that have worked with previous attorneys and they come to us saying, I've worked with this attorney. Sometimes they've given them the money and the person is not responding to any inquiries. Is there any recourse for these people at all? I mean, we kind of, ask them to sign a G-28. We kind of contact the attorney ourselves saying, hey, your clients come to us, they're looking to work with us. We want a copy of their file. Here's a G-28. Can you send it to us? But it just seems like a lot of people have worked with somebody and the attorney or whatever agency has just dropped off the face of the earth to them. So is there any recourse, legal recourse, or is it just a matter of us as, another representative contacting them and saying, you need to send us the file. Here's the proof that the client wants to work with us.
So one of the things I tell people a lot on the phone is, sometimes when a client files a complaint with me and I start asking questions, sometimes the lawyer realizes they should respond to the client. Sometimes that changes things.
Mm-hmm.
Obviously I can't force them to do so. I don't know. I guess supposedly the case file is their property and they could sue the prior counsel for it. I've never heard of anybody doing that, but it seems that it's their property and they'd be entitled to it.
I'll be honest, part of my intention in having this session is to incentivize people to report unethical conduct and exploitation, like what you're describing, because I think it's terrible. And sometimes, I think this is what Danny's getting at is, if there's a little bit of accountability, sometimes people will give back fees that were unearned, or they'll be more willing to hand over the file. So I've done that in response to what you're describing.
Yeah, and the attorneys who represent people frequently before my office kind of know that, once we send a letter of inquiry out, like the actions the attorney takes after matters. If we send them a letter, it says, you're withholding your case file from your client, and they don't have a reason why they're doing that. They're just being neglectful or whatever the case may be. They know that it's better for them to turn the case file over so they can send a response to me that says, yes, you're right. I'm sorry. I fixed this problem. And that depending on the circumstances, that might be enough to get me off their back.
Okay, Mary Alice, go ahead.
Thank you so much. And as always, it's so great to see you, Jen, and thank you, Danny, for doing this. I had a chance last January to be out in Tucson, and I was working at the shelter, the immigrant shelter, where the Border Patrol was bringing all of the migrants to. And so, as a bilingual person, I was doing the intake, helping with that. And one of the things that we did was we looked at the paper, the documentation that they got from the Border Patrol to give them permission to travel to where they were going. There were two things that bothered me about it. One was that we had to inform the person, that we had to highlight for them. The Border Patrol had told them that, they had a court place to go to and a time or a date, to get to that. And then also they had to, as soon as they got to where they were going, they had 90 days to call this number and just check in that they had arrived at where they were going and I guess get a court appearance, but not before a judge. So what I was not totally clear on is that Danny was saying that, when you're filing asylum, you've got that 1 year to say, I'm whatever that meant. And So some of the people had like a court date that was 3 years out. Some people had a court date that was 6 months out. And I'm just curious, if they would have gotten to where they were going, they would have made a phone call. They had a list of advocates that, they were encouraged to call to find representation. When does that 1 year ban start, and what do those documentation dates mean? The 90 days to call when you get there to let somebody know you're in the country, and also the significance of that court date in terms of filing within, the 1 year. That's what I'm just, if it's possible to, I don't know if that's a lot and I should go back to my books and look, or if you
Yeah,
can say.
no, that's okay. It's because it's a lot of moving parts. So a couple things. One, the 1 year clock starts at entrance into the US. But there's also a changed circumstances exception to the 1 year bar too. Like if things all of a sudden erupt in home country and the person has been here for 15 years, but all of a sudden things are terrible, they could still have a great argument in response to 1 year bar. People forget about that. That's why I mentioned that. So that's a 1 year bar. You can file for asylum outside of a court date, even if it's scheduled several years out. You can also file the I-589, the application for asylum, without all your supporting documents if you don't have time to get all that ready, and supplement the file later. That's very common practice. So you just satisfy that deadline. What I think you're describing, but I don't know for sure, is like an ICE check-in. The 90-day thing. That's my guess, but I don't know. I don't do border work. But there's all sorts of ICE check-ins.
That's what it sounded like. It was like an ICE check-in, and some people would get a ankle bracelet, I guess.
Yeah.
Or have to do the 1 week check-ins. All of that seemed to be related to that. But the 1 year bar would be they would have gotten a lawyer, and then that lawyer would have filed the paper that started the ball rolling for asylum, and then the court date is when they would present that case of asylum.
Well, so there's generally two types of court dates in a situation like that. There's a master calendar hearing, and then there's the individual hearing. So master calendar hearing is kind of a weird, like check-in hearing, almost like a preliminary hearing in a criminal context. You can file things there. You can discuss procedural issues. Sometimes the judge just wants to see the client. But that's just like a, lower level hearing. Client has to go to, though, because they'll be ordered deported if they don't attend. And then the individual hearing is the actual trial where you present the merits of the asylum application.
So there is absolutely nobody's going to get permission to work in that scenario, correct?
Well, so for an asylum seeker, they can apply for work authorization 150 days after the submission of the I-589.
Okay, gotcha. Okay.
Or I'm not sure what I just said. They can apply for work authorization. If that's what I said, that's what I meant to say. They can apply for work authorization 150 days after the submission of the asylum application.
Okay, that question came up, and I wasn't giving anybody legal advice, but I was just sort of remembering that I wanted to look this stuff up. Thank you, Jen.
Sure. Go ahead, Juan.
Yeah, I just wanted to piggyback on what Mary had said. I think she was talking about the TPS, or the parolees that have recently come in, because I've had some come into my office and they have to check in with their parolee every so often. And I think that's probably what she was talking about. And
there's all kinds of check-ins, all kinds of mechanisms with all kinds of agencies. I'll be honest, it's so vast. It's hard to know exactly, what is what in like a vague explanation like that.
Yeah. It kind of sounded familiar too, because that's what I've had come into my office.
Yeah. Okay, so let's transition to the federal regulations, just because I want you to see that before we end tonight, and we'll end at 8. And any subsequent questions you have or anything for Danny, just shoot me an email and I'll respond with an answer. Thanks, Danny.
Thank you, everybody.
Okay, so let's pivot again and go over these federal regulations, because for most of you, that's what's most applicable to your practice, like if you want to become a DOJ rep. Okay, so I'm going to put in the chat, these are the citations. Okay, so you can see those are bullet points. It looks kind of weird. So accredited representatives, those are the individuals, right? And then that's the federal regulation that contains the ethical rules for the individuals. And then the next one is for recognized organizations, like the nonprofits that host the accredited reps. These are the CFRs that apply to the organization. So this body of rules is pretty easy to read, I would say. Like, it's pretty self-explanatory. I think they're easier to digest than most ethical rules for lawyers. It's also not fleshed out enough. Like, for example, there's not a conflict of interest rule in the federal regulations, and there absolutely should be. Like, that's a problem that's not in there. But I just wanted to highlight for you the things that I think come up the most. So I'm going to copy and paste just from my notes here, just so you can keep it if you want to. Give me 1 second. I lost them. Okay. So these are things to be wary of, like yourself as an advocate, and also to look out for, you know, when you're at a new organization, maybe you think things are a little funky, things to be aware of. Okay, so the first one, and they're organized by the alphabet here. Like, this is the part of the reg based on the alphabet. So J is the first one that really stuck out to me. Engages in frivolous behavior, knows or reasonably should have known that actions lack an arguable basis in law or fact, or causes unnecessary delay. So I'm highlighting this because I've seen it before in the nonprofit sector. So nonprofits can have DOJ reps, right? We might not be vulnerable. We might, as like nonprofit workers, be incentivized by financial gain, right? Like you see in the private sector. But you see other unethical conduct like this, where a nonprofit doesn't know how to handle a case type and they think they do. And then they file that case type for people, and it's like an automatic denial for the client. So that would be this one. And you can understand why it happens, right? People want to help, and then they just get in over their head and they file stuff they shouldn't file, rather than, frankly, having the humility to turn people away when that's the right thing to do. Also, it's interesting at the end of that little regulation, it says causes unnecessary delay. So one of the tricky things about immigration practice is sometimes you are trying to buy time for your client for various reasons, but you always have to have a basis for it. So like anytime you file a continuance request, it needs to be in good faith, right? Like you can't just file a motion for a continuance and have like some bogus reason in there. And I've seen this often, that advocates will do that because that's what their client wants, but there's no arguable basis. So that's arguably unethical. And hopefully all this is kind of obvious to you, but sometimes when you're in a situation where you see this stuff and you think it's wrong, but everyone's doing it, it's a little hard to speak up unless you know that it's, you know, an actual rule violation. Okay, so K, and stop me if you have questions or comments or if you've seen this stuff before. Engages in conduct that constitutes ineffective assistance of counsel. So that's related to the next one. O, fails to provide competent representation. So this is kind of self-explanatory. All of us as advocates are exposing ourselves to the possibility of being found to be ineffective, like in a court order from an immigration judge, for example. But we can really prevent that kind of situation by having, again, the humility to know what we do know and what we don't know. And when we just need to tell people that we're sorry, we don't understand the case type well enough to take on the representation. Okay. And that one of the reasons why I wanted to have Danny talk about matter of Lozada, which I'll just repeat that briefly. Matter of Lozada is when the client files a motion to reopen or reconsider based on their prior advocate's ineffective assistance of counsel, right? So it's an accusation against the prior counsel or advocate that they did something wrong. Because that exists as like a a pathway for relief for immigrant clients, there's kind of an incentive there, right? So we have to protect ourselves against that. I've actually had a judge one time kind of threaten me with a Lozada claim because I was proposing an argument that was like, I don't want to say far-fetched, but it was novel and creative, but it was still cognizable. Like it was a legal argument that was definitely legitimate, but not one that would had a great chance of winning. So anyway, the judge kind of threatened me like, hey, this could be a Lozada case if you don't handle it correctly. So it's just helpful to be aware of that. Okay. P, super important, fails to abide by a client's decisions concerning the objectives or representation and fails to consult with a client. So this is really easy to do when you're really busy, right? So one of the ways that I deal with this, excuse me, is, say you take a client for a case type like a U visa where the wait time's long and the client is kind of living under the radar. They don't have status. They've been in the United States. So it's risky for them to present themselves, right? Because right now the government doesn't know about them. And in turning in this case, the government will know about them. Maybe not their address, because maybe you'll use your own address, your office address, instead of disclosing their home address. But regardless, there's risk there, right? So one of the ways that I deal with this is, again, I put it in the retainer, the risks that they've been advised of. And then before I turn in the case, I always check in with them and say like, hey, the case looks good. It's thorough. We've covered all our bases in terms of the elements we need to prove. Are you comfortable with me submitting this? And would you like me to go over again, like the potential benefits and risks? Because you really want to keep your client involved and make sure that they have the autonomy to make their own decision because this stuff is so complicated. So a lot of times it requires more than one explanation. But at a minimum, you definitely have to have that one explanation. And that's also one of the issues that Danny was explaining about that asylum cancellation scheme is a lot of times attorneys, it's generally in private practice when they're running that kind of mill with that like trajectory of asylum to cancellation, they're not explaining this to clients at all. So clients don't know what they're getting into, and they're put into, high-risk situations as a result. Okay, so a couple other ones that I think are pretty self-explanatory. Q is reasonable diligence. R, communication with client. That can be tough if you have a demanding client calling you all the time. And clients tend to be stressed about these things. But there are ways to handle it depending on your personality and maybe how direct you are as a person. Like I've told clients before, if I file a case and I'm not going to hear anything for years, I tell them that. And I also sometimes like, please don't call me every week because I'm going to tell you the same thing. It's a waste of your time. So the point is, like, I think being direct with communication is valid and important. Okay, so T, repeatedly fails to submit a signed and completed entry of appearance. Super important. Okay, so the entrance of appearance form is a G28 or an E28, right? The reason why I wanted to flag this is because it can be an indication that an attorney or a DOJ-accredited representative is running a mill where they're exploiting people and they don't want their name on the filing, right? They just want to accept the funds or accept like the case count toward their nonprofit grant numbers, right? So this is really important to be wary of. It can also come up with like pro se clinics. So pro se clinics are often very well intentioned. So if you're not familiar with them, that's where like you have legal advocates who provide like very short-term help with cases like asylum, but they don't provide like the full-scale representation. So I've seen it look different ways with different organizations, but you have to be very clear about what you are providing and what you're not providing. So if you're helping someone fill out a form, you should really submit your entrance of appearance. So if you're not doing that, I would just be careful because I think there's some exposure for you as an advocate. Okay, and last one I wanted to highlight for you is the boilerplate filings. So you can probably see where this is going at this point. Again, this can be an indication of a private law firm or a nonprofit just running a mill, like not providing high quality representation, filing the same stuff for a bunch of different clients. And I've seen this in both, in law firm settings and in nonprofit settings. And it's really hazardous for the client because even when it's the lawyer doing this, which usually it's a private law firm doing this, right? And they're getting a lot of money for it. The client is still charged for it, in my experience. That's what I've seen. Like they didn't necessarily know what was being filed, but they're still, like, once the government understands what's happening, they're still charged, like issued a new NTA where the charge is related to like fraud or something of that nature. And the client has to defend themselves against that. But it is helpful to know, like, there are some instances where boilerplate language is kind of normal, like if you're doing a motion to change venue, right? Because those can look very similar from client to client. Or if you're, say your nonprofit has a boilerplate confidentiality agreement or like a retainer agreement, that can be appropriate. This is just related specifically to the applications that are submitted for relief to the government. So those are the big ones that popped out to me. Hopefully that was helpful. Any closing thoughts, questions? And any questions I didn't get to, I'll respond to via email, and because I think I glossed over a couple of them. So that was a lot of content to cover. Thank you all for coming out.
Thank you.
Jen?
Thank you, Jen.
Yeah, it was great
to
to
meet
see
your
you all.
husband.
Yeah, thank you.
So that was fun. Okay, have a good night.
It was.
Thank you.
Have a good night, everyone. Thank you.
Bye.
Jen.
Bye.
Bye.